Welcome to Show Money, the only show exclusively dedicated to the business of mixed martial arts. I'm Paul Gift, your economist and MMA analytics guy from Bloody Elbow, and joining me today we have Jason Cruz, our lawyer from MMA Payout, and we have the man who knows every single thing and everyone in mixed martial arts. His name is John Nash from Bloody Elbow, and don't touch him in the face. Guys, it's the antitrust or litigation episode, I guess, right?
Yes, most definitely. And so we got some big news here with the UFC antitrust lawsuit. There was a decision by the San Jose court in which they have transferred the venue of the case from San Jose to Las Vegas. So actually, Paul Gift was at the hearing last month. Paul, can you fill us in on the details and what your thoughts of the decision were?
Yeah, and real quick, just to let everybody know, the things we're talking about today are the UFC transfer, a little bit about the FTC investigation that's possibly going on, that we think is going on, and Premier Boxing, what's going on with that big antitrust case. But so, yeah, I was at the transfer hearing a few weeks ago in May and got to see the proceedings in action. And it turns out that the judge transferred the case for two reasons, one being convenience, and the other one was based on contracts. And that was the one at the time that the judge was most focused on, the fact that 7 of the 11 plaintiff fighters signed a contract that had a clause in it that says this: Zuffa and fighter hereby expressly consent to the exclusive personal jurisdiction and venue of the state and federal courts located in Clark County, Nevada. And here's the key phrase: for any action brought by either party to interpret or enforce any provision of this agreement. So the big debate during that hearing was that the UFC was arguing that this is an action to interpret, that there are clauses in fighter contracts that there's going to be an argument about what role they played in this story that the fighters have of contracts being used as exclusionary weapon to keep other promoters from having access to fighters. And the plaintiff side, Joseph Saveri, was essentially saying it doesn't matter what the clauses say, what matters is their effect. And so the judge was a little bit skeptical at the time. You could tell that he kept questioning Saveri over and over again. You know, if we're going after effects, don't we have to interpret the clauses in the contracts? And it turns out that the judge at the end of the day here, just what was it, yesterday, 2 days ago, said yes, these are actions to interpret contracts. And so we are headed off to Vegas. And I do have to say, selfishly, the one nice thing about them heading to Vegas is for any other major hearings, it's a lot more fun to go to Vegas than San Jose.
Speak for yourself. I like the Bay Area. No, it's way too expensive, actually. So.
I can't wait for that motion to dismiss.
Yeah.
Wait, honey, excuse to go to Vegas.
Yeah, blow it up. But it's no, I'm not a fan of the I guess the decision it was based on. I believe that I'm not saying I'm not a fan of the decision to move to Vegas. For convenience sake, that makes a lot of sense. That makes a lot of sense. I'm not a fan personally of the. Was it the American Express versus Italian Colors restaurants Supreme Court decision that said that if it's in a contract that you agreed to, you have to go to that venue. When you're talking about antitrust and monopoly, when the argument is that we were compelled to sign these contracts because you have a monopoly, that doesn't make sense to me. But going to Vegas, that the convenience side makes sense. And thank the Supreme Court, Robert's Supreme Court, for that previous decision.
I think that if you read the court order, you could see that the judge just didn't buy the argument set forth by the plaintiffs. It was, what does the contract say? That's what it sounds like, that the judge was really impressed upon by the fact that there was a forum selection clause and that these fighters signed it, regardless of the circumstances that brought forth them to do that. So it's really a hard pill to swallow for the plaintiffs. It doesn't mean that the case is necessarily over just because it goes to Vegas. It just means that they're switching venue, and so we'll see what the new judge does and how he sets forth the rest of the case. From what I understand, there was a motion to stay discovery in San Jose. It appears as though that still will take place, the hearing or the hearing of that case. It's just going to be pushed back a little bit because of the transfer. And Paul, I'm not sure. Do you know if the motion to dismiss is still set for July, or do you know if the court is going to push that back as well?
Well, so they were making arguments in the motions to stay discovery. They were making arguments that in doing that they didn't have to change the motion to dismiss hearing, but nothing was said about after you actually transfer. So all their paperwork is filed, but there hasn't been anything that I've heard about whether the motion to dismiss hearing is still set. And one other thing to let people know really quick. What's that?
Oh, I'm just saying it's not going to be July. It's been it's wiped the slate clean. Everything's got to be rescheduled.
That's what I would think, because the other judge needs to get caught up on everything. But one thing to say, just in case people were wondering about the fact that because 7 of these guys signed their contracts, but 4 didn't. One thing that was abundantly clear in that hearing, both sides were talking about, and so the UFC especially saying, look, we have 7 guys who signed these clauses. 4 of them didn't, but you can't just sort of bring someone one person who didn't sign the clause into your case and use that person to say, hey, we get out of this. We get out of the fact that we signed it now. And the judge was in complete agreement with that. It was totally clear in the hearing that the fact that 4 people did not sign those clauses was not going to have any effect.
Yeah, well, I mean, it's, I guess it's good for the defense. Zuffa's lawyers did their job, and they've got to be happy it's going to a friendlier venue. I mean, Vegas is famous for being a slightly, more business friendly, but I don't think it's the end of the world. I mean, a lot of people were. My Twitter feed was just blowing up with people either, depressed, thinking, "Oh my God, it's these horrible, corrupt people won," or other people are posting celebration. "Oh my God, thank God, these terrible losers lost their case." It's not over. I mean, the defense is actually kind of happy now. I'm pretty sure with the judge they got. He's an Obama appointee. He seems to be slant from the I guess the more liberal side of the aisle, so they got to be happy with that. And also everybody I spoke to before, the plaintiff side, the defense side, outside experts either thought it was a coin flip or thought it was favored to go to Vegas. So it wasn't like, from my sense, I didn't get the sense that their whole case was based on the idea that they're going to be in the Bay Area. So it's
right.
We'll see what happens. Motion to dismiss is the next big hurdle. Everybody I spoke to still thinks it gets by motion to dismiss. Maybe not as easily as it would have gotten in the Bay Area, but they still think it's by motion to dismiss. The big part is when we get to class certification, if it gets past motion to dismiss. That's the part people think the bigger hit of moving from the Bay Area to Vegas is.
Yeah, that could be. And I'm interested to see actually how this. The one thing that interests me after the judge's ruling is he made specific note about the plaintiff's lack of specificity of he's like, you could have just written in here what the contract said. You didn't do it. So I'll be interested to see if that plays any role with this whole lack of specificity stuff when it comes to motions to dismiss. And another thing is that this new judge, we found out about him today. This new judge is pretty much 1 year in right now. It's very well possible, being in Nevada, that he's never had a major antitrust case on his plate before. I don't know if that's true, but it's very much possible. This might be his first one.
I don't know if Nevada, if I remember, they don't do many antitrust cases. Right. So there might be many judges sitting over there in the federal court that have never done an antitrust case. So
we can probably positively say that this is his first involving mixed martial arts. So Yeah, I definitely think that it'll be interesting to see how he handles both parties and how it will proceed in Nevada. I definitely think that the plaintiffs had to have this in the back of their mind, as John had alluded to. They took their shot, and it didn't work out. But now they're going forward into the other phases in hearing the motion to dismiss and the motions to stay discovery and things like that.
Yeah, if we go off the judges, uh, whatever, all those, what am I can't, oh, like I don't know what I'm talking about. If we go off all the things he was saying about boxing and mixed martial arts and all those things that he was putting in his decision, it's only a 9.5 round to me. We're using half-point scoring here. Yeah. It is not the end of the world.
Oh, so yeah. So just what Paul is alluding to is in the order, the Judge Davila, I believe, put in some boxing references, and one of the things he says at the final bell is defendants' arguments that clinch the round because the relevant forum selection clause and the convenience factors favor Nevada. He also indicated that Zuffa was the heavyweight of the MMA industry, and he also indicated that Zuffa sought to knock these cases out of Northern District Court of California and into its home venue. So, very spirited and relevant, I would say, written opinion. I don't know if the law clerk that clerks for him is a big MMA fan. So, I mean, if you would think that if he was a big MMA fan, they'd try to keep it in. But
I think I would appreciate it more if it was a little wittier. Actually, I wasn't. It was, if you're gonna try, at least nail it. I mean, but and for people curious, the new judge is what? Richard Boulware?
Yes.
Honorable Richard Boulware is the new. And
judge. Actually, maybe Jason can clear this up for us really quick. There are two different judges technically right now, because the Kingsbury. So what I saw today is they moved the Lee case, but then Kingsbury got moved as well, and that got a different judge. But I believe those cases are already related.
Yeah.
And you think that I think the Lee judge wins out, does he not?
I would think so. I don't know how it works in Nevada, but I think that the lead judge. You said the lead judge, correct?
But Lee, not lead, but Lee.
Lee, yeah, the lead judge would be the one because I think that's who they're going with. So if someone practices in the federal courts of the District of Nevada, Mr. Cardenas, you can let us know.
So anything else on this transfer?
Not for me. It's it's another waiting game. We'll be a while before we get some more news.
It's another waiting game. Get to travel to Vegas, which is nice. And John and I don't think it's nearly the end of the world that some people are making it out to be. Jason, what do you think?
I don't think it's the end of the world. I think, like I told you guys off the air, I've been in cases where everything is going A-okay as we go along, and then you get to the judgment, and then you're like, what happened? And you wonder what's going on. So this case, just like a fight, will have its ups and downs, and I don't want to harken back to Judge Davila's opinion, but it'll have ups and downs, and you would hope that the plaintiff's lawyers will come back, or motion to dismiss, and then we're looking at something else in this summer.
I am interested to see if Severi takes the lead in these hearings going forward, because I think the general consensus is that he kind of flubbed it up a little bit, or at least wasn't making the best arguments in this other hearing. So we'll see. Yeah. We'll see if they keep him in there or move somebody else in.
They're going to have to get someone in Nevada to represent them. They're going to need a firm, a local firm or attorney, someone to do all the local stuff. Otherwise, it's pretty inconvenient to have everybody fly in for minor paperwork and stuff. So maybe they'll get. I'm not. Problem is, who do you get in Nevada that doesn't do business with the Fertittas?
You get the old mayor, right? Doesn't everybody get him?
Yeah.
When is the bar in Nevada? Maybe I could take it.
Jason will be sitting there being like, guys, things are going great. We're doing so well. Oh, fuck, we just lost. All right, so we're headed to, we're going to shift gears to the FTC investigation that seems to be going on. Our guy John evidently almost broke the news of the story, so you want to fill people in on what you heard?
Yeah, apparently, I mean, there's no way to really confirm it, because if you contact the Federal Trade Commission, they will neither confirm nor deny. But apparently, it seems like the FTC has opened an investigation into the UFC's business practices. And it's either reopening the old 2011 case with Strikeforce that they closed in 2012, or it's a new one. It's hard to tell, since no one there is going to talk to you. But based on the number of people they've contacted and the questions they've been asking and the long interviews they've been conducting, it's pretty safe to say it's a full investigation. I talked to our friend David Dudley, former FTC antitrust lawyer, to get his input, and he knows nothing about the specific case since he no longer works there, but he said if they're doing that much legwork, it's pretty safe to assume that it's a full-blown investigation. So based on the conversation, I know they've talked to I've talked to 8 people that they've contacted. Some of them they've had several phone calls with, and right now it seems like the big thing they're trying to do is research, because they don't really know how MMA works and the business landscape works. So that seems to be their primary focus right now. So what happens? Who knows? What are they investigating? We can only guess.
Yeah, and for those who don't know, the Federal Trade Commission and the Department of Justice only generally get involved in these things when public interest is at stake. The phrase they sometimes use is public interest may require it. So it says something if they're opening an investigation. They never just open a general investigation. Usually, I don't believe, as to just what are you doing. There's always there's usually some focus on certain business practice. So they investigated Google about 2 years ago, and Google pretty much got out of the investigation scot-free. Just had to change 1 or 2 things. That'll sometimes happen. Sometimes they'll do a full-blown lawsuit on you. Sometimes they'll just ask you to change a couple of your business practices, and that's it. So it'll be interesting to see. I can't wait until we actually hear something from them, because eventually it'll go from non-public to some sort of public. But I don't know exactly when.
Well, we had attempted to attempt a FOIA request for their previous FTC investigation, and what I got were 6 pieces of paper which were basically nothing, and a letter saying that they do not divulge any information, basically any work product where they're doing an investigation. So basically the FOIA request really was nothing. And it'll be interesting to see what was the reason for them to investigate this time. If I recall, last time when they opened the FTC investigation, it was related to their acquisition of Strikeforce. This time, I assume that it's just that it's not just, but it is because of the antitrust lawsuit, and maybe they just needed to recalibrate and see if there anything with the acquisition, with their acquisitions in the past and what is going on now has raised any red flags with them. So we will see if anything gets out. Maybe there'll be more information in supplemental FOIA requests. We'll see.
Yeah, based on the conversation I had with people, the guess, if people have given me 2 guesses based on their very long conversation with the FTC, what they're investigating or what reopened the investigation. And apparently the 2 guesses is, one is that they closed the original investigation, according to one person, because they saw that Viacom was entering the MMA sphere, and so was other promotions. They thought, we'll see if the business, if it corrects itself. Barriers of entry, no barriers of entry, other promotions come, it should correct itself. And that they've reopened the investigation after the lawsuit was filed, realizing that it doesn't seem that the market has corrected itself, that the UFC's control of the market seems to have grown. That's one hypothesis given to me. The other one was that the FTC, after the purchase of Strikeforce, that they didn't see any changes in the market at all, and so they closed the Strikeforce. They closed the investigation because of that, and then only later, with the lawsuit was filed, do they go back and start wondering if that there was it the Teflon effect, that the market might have already been askew before the purchase of Strikeforce, and so that they wouldn't have registered it. That's the two theories given to me, which are pretty long-winded and pretty complex theories, and I don't know if I somehow not sure the FTC told the people that, but that was told to me. So.
Yes, and as we've talked about many times before, that market already askew argument I do not buy whatsoever. It makes no sense to me. But the other one seems perfectly possible. It's curious as to why they would investigate after the private lawsuit already takes place, because it's kind of like when Department of Justice went after Microsoft way back when Microsoft was, everybody used to fear them, which they don't anymore. But yeah, the Department of Justice took that case, and Netscape didn't have to sue them. But this comes afterwards.
I think David Dudley's theory was partly they, to cross all their T's and dot their I's, that they were worried that they didn't do a thorough investigation last time. When there was evidence maybe in that lawsuit or some sort of presentation in the lawsuit that alerted the FTC, and they thought we didn't look into that, and we should look into it. So the one thing in David's theory was this is going to take a while, because if they reopen an investigation of someone, they're not going to close it quick, because they have to make sure that no one can come back and second guess what they did. So whoever's investigating is going to spend a great deal of time investigating the UFC. So UFC, they better get ready for a ton of paperwork, because that's the way it is.
So it's pretty safe to say that MMA fans can feel pretty comfortable that we've got a private lawsuit going at them and the FTC checking them out.
How thankful am I that I did all that research on antitrust? Monopoly. I am so thankful that it did not go to waste.
All right, so let's do hypothetical here. Let's say that the private case ends and the FTC investigation ends and nothing happens. What do you guys think? How do you guys think the market moves forward, or the players in the market, managers, fighters? What do you think? What do you think they do moving forward?
I think it depends on where the private lawsuit ends and what is the resolution. If it's a motion to dismiss, I see business as usual for Zuffa. If it is in a mediation or some sort of settlement, we could see some positive things for the fighters in terms of how they're treated and whatnot. What happens in the FTC investigation, I'm not completely sure what can become of that, or what will transpire as a result of their investigation.
John, any thoughts?
If nothing happens on both cases, I would say then it's business as usual. UFC, I guess, tightens their control, becomes more and more of a league. I guess the other potential would be some sort of federal intrusion with like an Ali Act or something, because of the way the UFC operates. But if they become more and more of a league, managers are already practically useless. So managers, if nothing happens in both those cases, I think managers basically drift out of the sport. You'll have very few working in the sport. The fighters, I guess, the fighters' option then is some sort of organization, either association or labor organization. But the other option too is that something small happens in either case, and is that your phone, Jason?
Yeah, sorry about that.
Oh my gosh,
that is some loud.
That is
vibrating.
I can feel the vibration in LA. I lost my train of thought, which obviously wasn't important anyway. So, but no, I think business continues. The UFC dominates the market more and more. The network effect, as we've talked about, takes over more and more, and the other promotions are relegated more and more to the minor leagues.
Yeah, and one thing people should watch out for, fighters might be concerned about, is that in so many of these cases, back to the private antitrust case, the settlements are just sometimes they're almost laughable. I mean, I was working on one case where the settlement was, you can't do this for 4 months. 4 months. And then 4 months and 1 day in, they did exactly what they were doing again, and plus worse, like extra. So I mean, so when you talk about possibly getting a settlement, you want to. A big concern is this thing better be good, because sometimes you get your settlement, and you have to live with it, and it's almost a joke. But all right, guys, so that's something to look out for with the FTC investigation. Now we're moving into boxing. A little bit of Golden Boy, a little bit of Al Haymon, a little bit of Premier Boxing. How long ago was it? A month? 3 weeks?
Yeah,
4 weeks? 5
yeah,
weeks?
it was actually, I don't know if they did this on purpose, but Cinco de Mayo, May 5th, Golden Boy files a lawsuit against Al Haymon.
Easy to remember.
Yeah.
Okay, so I'll give the basic idea of what this lawsuit is about really quick. It's an antitrust lawsuit filed by Golden Boy. So to distinguish it from the UFC's lawsuit was filed by fighters, claiming the UFC was excluding promoters. In this case, a fellow promoter is filing the lawsuit, claiming that someone is acting as a manager. Al Haymon is acting as a manager and a promoter, and engaging in conduct that in the future will exclude them. That's one key difference from these two lawsuits. The UFC one, they're saying the UFC has monopoly power and is maintaining it already. And in this one, they're saying that Al Haymon will get it in the future. And so that makes it a little bit harder of a hurdle to overcome. The easier hurdle that they have, though, is that it's not about exclusive contracts anymore. They're about two things. This case is about two things. Predatory conduct with, I can actually share what they say, on the part of the way that Al Haymon is going to TV networks. The predatory conduct is when you price really low, try to drive somebody out of business, and then jack your prices up later. And so what Golden Boy says is that Premier Boxing has reversed the ordinary flow of money from the network to the promoter. Defendants pay the networks to broadcast their bouts rather than having networks pay them. And once they have achieved the monopoly position they seek, defendants, being Premier Boxing and Al Haymon, will exercise their economic power to reverse the financial arrangements, recoup their losses, pay less to boxers, and reap massive profits. So we have the predatory side and then the tying side. The tying side is when they're saying Al Haymon is acting like, it claims he's not a manager, but he is a manager, and he has dominance in this managerial market, and he's forcing his fighters to use the promoters of his choice, which will mostly be him, and he's going to leverage this power into this other market and kick Golden Boy and other promoters out. That's the basic idea of the arguments that are being made. All right, so first question to you guys is Al Haymon a manager from what you see? Because he can say the best way to get out of this is how can I leverage managerial power when I'm not a manager?
Well, Al Haymon claims not to be a manager. He claims to be an advisor. He has a whole new position in boxing. He's an advisor, and they've done a smart job with PBC Boxing. Is they made several layers, because what makes this case different also from the UFC case is the Muhammad Ali Reform Boxing Act is involved. There's federal law in boxing that only affects boxing, doesn't affect MMA. Apparently, only boxing is tormented by these problems, and other combat sports are not. So they made a special law for boxing that says these things are forbidden because there's a long history of them being abused. And Al Haymon has done a great job of putting some sort of layers of barriers between him as an advisor and the managers of the boxers he advises and the promoters he works with, even though he's basically dictating the terms to all. And in the Ali Act, there's a firewall between them. You cannot be a manager and you cannot be a promoter. Those have to be separate. Their interests are considered to be in conflict. And a manager has fiduciary duties and a promoter doesn't. So they want to keep them separate. He also, to get off on a tangent, which is not part of the Golden Boy lawsuit, the ABC wrote a letter to the Attorney General asking him to be investigated for violation of the Ali Act. I found this fascinating. They cited one of the problems they had with what he's doing is he's trying to be like MMA promoters. And that he's acting as a sanctioning body and as a promoter. So
and you have to share the evidence that they had. That one piece of evidence, you have to share it.
Oh, that the talk that they're going to make they're going to make belts.
No. There was a photocopy of his Nevada license application. Remember?
Oh yeah. Yes. He's like,
To
but
be a manager.
yep, to be a manager. So that's his evidence that he's a manager. But that's the Golden Boy, not the ABC letter. I thought you were talking about the Attorney General letter.
I thought that was an ABC, not Golden Boy.
Oh, maybe it was. Damn it, maybe I'm getting confused. I'll have to Exhibit A. Yes, you're right. Yeah, because they gave a contract showing him, and they gave his license application to the ABC.
Right.
Yeah. And there's a signature. I'm looking at it right now. It is a very nice signature. But I think that's fascinating. So, I mean, Jason, I guess from your point of view, what do you find so interesting about this case?
I think the funny thing about it is that here they are, Golden Boy, talking about, the foreclosure of the market to TV, where they're talking about a time buy and saying that this is Al Haymon, paying networks to produce his product is unfair. That's essentially what I believe Haymon's lawyers are going to say is like, Your Honor, I mean, we're just, we are a business wanting to pay money to a network, and the network is willingly allowing us to put our product on the air. What is the problem? What is the issue there, Your Honor? I mean, and so like as Paul has put it, is that it seems as though it's going to be a hard argument because they're trying to argue in the future. Well, in the future, they're going to foreclose the market and everybody's out, or every other promoter is out. And you're going to have some sham promoters. I think they said that's how they characterize these promoters who are just really working for Al Haymon, but are other promoters. And so it'll look like that there is a market, but not really. So I think that's fascinating. I also think the fascinating thing is they indicate that an article in the Sports Business Journal really kind of assisted their lawsuit. And for anybody that wants to know, you could go look at it. It actually was up for free, and it interviews the fund manager, I believe, for that is funding PBC and Al Haymon, and I thought that was kind of fascinating as to why they wanted to do it and how they did it. So, and there you go. There, Waddle, I believe, is the one of the defendants in this lawsuit.
Yeah, for people who don't know, which is probably a lot of people listening to this, because they don't do antitrust a lot, it's really hard to win predatory claims, because the idea of a predatory claim is you go into court and you go, you see those low prices over there? You see those low prices? That's really bad. Those low prices are bad. Make it stop. It's gonna be bad in the future.
What's interesting about this case and bizarre is when you look at it, if you're trying to prove an antitrust violation, or monopoly, abuse of monopoly power, it's gonna be so easy to prove against Haymon. You have $400 million, and you're basically buying up airtime on all the major networks, blocking other people from access, saying we can only be the only boxing promoter on these channels, we'll pay you, basically starving everybody out by flooding the market. That's pretty easy to prove, but the problem is, according to people I've talked to, is his boxers make so much that he makes sure they get paid so much that there's really no damages to the boxers. And that's the flip side. That he's making sure that he's almost protected himself from any sort of antitrust monopoly charge from the boxers because he's paid them so much, which is also interesting because he, as an advisor, gets 15% of those enormous purses they're getting. Genius business structure.
So what do you guys have? So how would you characterize Golden Boy on this? I know it's early, and from what we know, do you think Golden Boy has a serious claim here, or do you think this is just a sort of a competitor whining? Because that's what the question in every antitrust case: is this serious, or is this guy whining?
When you read the complaint, it's really well done, and I would say just first blush that it has a much better chance of succeeding passing a motion to dismiss than the Zutha lawsuit. And I definitely think that Haymon and his attorneys will have a much harder fight. Even though I made the point there about the time buy argument. I think that there's still some other issues out there that Haymon will definitely have to confront, or at least his attorneys will have to confront and answer to. So I think we haven't told everybody it's filed in Los Angeles Superior Court. So I think you guys can definitely attend the hearings down there. So we shall see. The Federal Court of Los Angeles, not Superior Court. Sorry.
Yeah. Right downtown. Perfect. I can take the metro. I don't even have to drive. That's great.
John, what do you think about Golden Boy?
I mean, I think it's obviously whining. On one hand, it's whining, but at the same time, there's actions taken there. You go, that does seem, an attempt of abuse of power. Abusing market power. And the other thing going for Golden Boy is there's federal law that Haymon, the PBC's got to explain that there's federal law on that with the Ali Act that adds to the charges that he's violating something. I mean, is it going to win or not? I don't know. I mean, Haymon, like I said, they've done a good job of curtailing the Ali Act, of skirting around the edges to make sure they're not in direct violation of it, at least, not obviously. So maybe they can get away with that.
And here's the thing about the Ali Act. If Golden Boy were to succeed, this probably will be the first time that the Ali Act will be successful for someone suing on behalf of it. So there have been tons of lawsuits where people have claimed the Ali Act against Al Haymon or or Golden Boy or Top Rank, and they've been either dismissed or they've been they settled out of court or something. So if this were to go to a trial, it would be definitely interesting to see how they apply the Ali Act in relation to what is going on in boxing. Because even though it is a great, I want to say prophylactic, but I don't know if that's the right word. It's a great way to protect boxers. We haven't actually seen it in actual legal practice. So it'll be an interesting case to see how it goes.
It's the protection so far has been as the law of the land, that people have been kind of following the guidelines and not obviously violating it, and that state state athletic commissions have been incorporating some of the elements into their rules on boxing contracts. Like, you can't have a contract clause extend over a year. That's in violation in California if you do that. So it's been a big help. And this is something I'm interested in your guys' take with that ABC letter. I'm just wondering, eventually this could open a can of worms with MMA being dragged in, that someone has to make a decision. Eventually, how can you have the Ali Act only pertain to boxing by claiming that boxing violates these things and MMA does everything right, so boxing has to have a special regulation on it, but then a boxer say, we're going to do what MMA does, and then say, no, by doing what MMA does, that's the violation. That, to me, seems, it's like something has to be given there at some point.
It is.
I definitely think that we're going to see a lot of boxing and MMA getting intertwined, especially when we talk about later on about drug testing. I mean, there is going to be an effect in the boxing world if Nevada and California are taking more stringent penalties against drug users. That's going to relate to boxing, and so here we are. Boxing here, the business practices of boxing, are going to relate to MMA, and we are going to see a lot of. Well, I don't want to see time because that's an antitrust thing, but we're going to see a lot of analogies toward the UFC, and I could foresee that the UFC and their lawyers would seem to be like, no, hey, let's keep your name out of my mouth, out of your mouth. I mean, we don't want to get involved in that. We got too many legal issues going around everywhere. So I do think, though, that you definitely will start to see that starting to happen.
Yeah, so first off, going back a few statements, whatever you were going to say, I don't think prophylactic was the right word.
Probably not. I always bring it up, though. I bring it up prophylactic.
What happens? It's live whatever we call this, streaming television. Here's an interesting part of the case to me. This interesting part to me. In order to win a tying case, here's what they have to show. They'd have to show that Haymon was a manager, that Haymon was a promoter, and these are two separate markets, that they're tied together, all right, that he has significant economic power in the managerial market, and then that he's leveraging it over to the promoter market, depending on whether it's per se or rule of reason, either affecting a lot of sales or an adverse effect, anti-competitive effect in the promoter market. Now, the interesting thing is, if any one of those doesn't hold, you do not win the tying case. But in this case, if those first two hold, that you're a manager and you're a promoter, right? Even if some of the other ones don't hold, maybe you don't win the tying case, but then all of a sudden you've got them on the Ali Act. That's kind of the interesting component of this case is that while you go for tying, you might not get it, but you might sort of, as a side effect, get him on Ali.
Yeah, that's the.
Yeah, go ahead.
Well, I'm just saying that's the interesting part. It's got all these layers and components, and I just find it fascinating too that they're, you know, like they said, they keep dragging. In the Zuffa case, they keep dragging the International Boxing Club versus New York, or International Boxing Club of New York versus the USA into that case, which is cited again in this one. It's a very important case, and people should look it up. And it has to do with the mob and stuff, so it's very fascinating. But it also has to do with business practices that you still see common in MMA and in boxing. And the other side is in the Haymon case, they keep bringing the UFC and MMA promotions into it, and they keep citing them. And I find that just fascinating that they're citing these examples of either what the other businesses do as examples of what's wrong. They're basically both showing, no, he's doing what they're acting like boxing. See how wrong he is? And boxers are like, no, that guy's acting like an MMA promoter. See how wrong that is? I strangely find that fascinating. It's like a shooting gallery. Everybody's blaming the other guy.
You pick and choose what works for you at the time.
Yes.
All right, guys. Any final thoughts on PBC, on Golden Boy PBC?
Well, it's nice to see boxing on network TV.
It is. It's actually a blast from the past. I do appreciate the fact that you can on a Saturday afternoon. It takes me back to when I was younger, where you could watch it. And the thing is, it's well done. The production is great. You get introduced to all these fighters, and I think it's good for the sport. I think it is. Is it good business practices? Well, we'll see. I think that this lawsuit will be an interesting one that people will want to look forward to. And I'm just really curious about this. As if you say, if they can't get you on the antitrust, but they can get you on the Ali Act, we'll see how that works. Because I don't know how the application of that act will go in court, how it will go down, how will the judge address those things, because it's really uncharted territory, I would think, because this is of a great magnitude. We haven't seen the Ali Act gets a lawsuit go to a jury, or I'm not sure if it's going to a jury or is it a bench trial. So yeah, we'll see.
But I find here's something for you guys really quick before we leave. I guess what would it mean to MMA if they applied the Ali Act to MMA? Reading that the allegations and reading how the rules are supposed to say, what would that mean to MMA? Because there's stuff inferred in the Ali Act apparently. If you read that letter to the Attorney General, you're not supposed to be a regulatory body or a sanctioning body and a promoter.
Yeah, so, no, I think
even though it's not explicit. I mean, basically, you would say the way MMA is done has got to be completely revamped.
I don't know if 100%, because they could get out of being a manager. They might be able to get out of a manager, but to me, the biggest thing, if you were to apply it, is that disclosure. What is it? Yeah. The promoter has to disclose all
the revenue streams, basically. And
yeah.
And that, believe me, that's the number one thing. I've talked to fighters and managers and stuff in MMA. That's the number one thing they wish they could have.
Right. I just have a feeling the UFC would be able to get out of the whole firewall thing, but you can't get around that disclosure.
Well, the firewall thing, I think they could. I mean, they'd have to do something about the sponsors, but I guess it's inferred in the Ali Act. It's not explicit against the Ali Act, but it's inferred that you cannot be a sanctioning body and a promoter.
Right.
And that's the part. I wonder if they ignore that, or if that would be a part someone would have to apply. Because right now the UFC is the sanctioning body. They own the belt. It's their belt.
Right.
You'd have to split those two.
Yeah, I mean, they'd probably say something like, "Oh, the NBA is a sanctioning body. Come on, guys, we're a different business model." But who knows?
Yeah, the cynic in me says that, how would this work out in MMA world? I would say I don't know if it would have any effect, simply because at present the Ali Act is great, but I think unless there is some sort of other avenue in which a fighter could have access to the use of the Ali Act without having to go through an extended litigation period in which they would have to expend a whole lot of money, or they would have to find an attorney willing to take this on a contingency fee basis. That practical effect of the Ali Act, or suing under it, is key. And I think unless there is an amendment where you can have an arbitration provision or a mediation provision or something where there is an ability to shortcut a lot of the fees, I don't know how much just a regular 10-10 fighter can make a legal claim unless a ton of people come together, or you got an attorney, or you got a pro bono guy out there with tons of money and just wanting to do the right thing. So we'll see.
It's an interesting world, you suggest, John. Interesting world.
Yeah, I just I doubt it'd have to be federal law. Would have to probably, it sounds like they'd have to change it, but it sounds like, it just seems to me reading that's like you guys just open a can of worms with that.
Yeah.
So we'll have to wait and see. And,
all right, guys. Are we good for today?
I think that was good. I think we actually finished the show. That's nice.
Oh, well, let's actually do the exit first.
Oh, yes.
So that's our show for today. I don't know how we're going to exit. We're going to talk about what we do next time. I think next on the schedule is the drug testing issues, which we wanted to bring sooner rather than later, but it looks like that's going to get postponed about a week. So we'll catch you guys next time, where we finish with the litigation episode, and next time we'll give our thoughts on the recent drug testing news. Take care.
Live long and prosper.
We need a good slogan to exit.
Keep showing. Let me check. I had an exit once, and I couldn't remember. It was like.
What was the first one about? There was the alternative name.
Business as usual. Business as usual.
Keep business. If this is show money, keep business as usual.
All right. Hey, this is show money. Keep doing business as usual. Did that work?
I like that. That